ICE is counting on one thing, that you don't know how to read a piece of paper. That warrant they shove in your face, right at your own door. Most of the time, it's worth nothing. Zero. No judge signed it. It was an officer from inside ICE itself who signed that paper. No one outside evaluated the case. No judge approved anything. It's the agency authorizing its own action. And they're counting on you panicking and opening the door anyway. And it works. Every day, in every American city. Entire families lose everything because no one ever sat down with them to explain a difference that changes absolutely everything. If you open that door without knowing what you're holding in your hand, you're not being polite. You're handing over the game on a silver platter. Stay until the end, because I'm going to show you exactly the paper they don't want you to know how to recognize. Not every warrant ICE shows at your door is valid. And that's exactly what most immigrants don't know until it's too late. Think about it. You're at home, in the morning, maybe still in your pajamas, and someone knocks on the door saying, "Immigration, we have a warrant." Your heart races. Almost everyone's first reaction is to open the door. Out of fear, out of respect for authority, or simply because no one ever explained that there's another option. But I need to tell you something that could completely change the course of your life and your family's life. Just because an agent says the word warrant doesn't mean they have the right to enter your home. Every day, in cities like Houston, Los Angeles, Chicago, Miami, thousands of immigrant families live with this fear hanging over them. And the problem isn't just the fear, it's the lack of information. Because American law is very clear about this, but no one sits down to explain it to you. So here's the question that's going to guide everything I'm about to show you in this video. Did you know there are two types of warrants? And only one of them gives ICE the right to enter your home? Only one, not both. And most people have never heard of this difference. This isn't distant legal theory. This is the kind of detail that decides whether a family stays together or someone gets taken away without even knowing they had the right to say no. I've seen this happen up close, more than once. The person opens the door thinking they were required to, and from that moment on, their options shrink dramatically. Once the door opens, it's very hard to go back. That's why I want you to stay with me until the end of this video. I'm going to show you exactly what the difference is between the two types of warrants, what to do if an ICE agent shows up at your door right now, which mistakes cost the most in the immigration process, and what the legal foundation is, the real constitutional protection behind each of these actions. This applies to you whether you're documented or not. It applies to mixed status families, where some people have citizenship and others don't, living in the same house. This information is yours, it's free, and it can be the difference between protecting your family or losing control of the situation in a moment of panic. Let's get straight to the point, because this is the most important part of all of this. There are two documents ICE can show at your door, and they look similar, but they carry completely different legal weight. The first is the administrative warrant. You'll see it on Forms 1-200 or I-205. The I-200 is the warrant for arrest of alien used when ICE believes the person has violated immigration law. The I-205 is the warrant of removal used after there's already a final deportation order against the person. Here's the key point. Both of these forms are issued by ICE itself, signed by an immigration officer, not by a judge. No judge reviewed the case. No judge approved that paper. It's an internal document of the Department of Homeland Security. Because of that, this warrant authorizes the person's arrest if they're found in a public place, but it does not give the agent the right to forcibly enter a private residence without your consent. The second type is the judicial warrant. This one is signed by a federal or state judge based on the Fourth Amendment to the Constitution, after a finding of probable cause. This document has your name, your address, and a judge's signature, and only this type of warrant requires you to allow entry. Now, pay attention to this. There's an internal ICE directive released in 2025 saying agents could use Form I-205 to enter the homes of people who already have a final deportation order. That policy is still being challenged in court, but the underlying principle remains the same. Always ask, always verify the signature, and always seek guidance from a lawyer after any visit. In practice, what often happens is this. The agent shows the paper quickly, talks fast, uses an authoritative tone, and expects the person not to know how to tell one document from the other. Most people really don't know, and that's exactly where the problem lies. Recognizing this difference in the moment, in the heat of the moment, with your heart racing, is what protects you and your family inside your home. It's not about disrespecting authority. It's about knowing exactly where their authority ends and where your rights begin. Remember this, an ICE paper without a judge's signature does not open your door. Only your decision opens it. Now comes the practical part. I want you to treat this like a protocol, almost like memorizing the steps of a choreography, because in the moment this happens, you won't have time to think calmly. Step 1. Don't open the door. Speak through it or through a window if there's one near the entrance. The closed door is your first line of protection, and it's legitimate. Step 2. Ask to see the document without opening the door. You can say calmly and firmly, "I'm not going to open the door. If you have a warrant, please show it under the door or through the window." This isn't rudeness, it's your right. You have every right to ask to examine the paper before making any decision. Step 3. Check whether it's signed by a judge. Look at the header, look at the signature. If it's not signed by a judge, if it's only an ICE officer, you can say, "This document is not a judicial warrant signed by a judge. I do not authorize you to enter my home." You're simply stating the truth about what that paper is and what it isn't. Step 4. If the agent insists, asks questions, or tries to pressure you into answering about your immigration status, country of origin, or who else lives in the house, you don't have to answer any of that. You can say, "I am going to exercise my right to remain silent. I want to speak with my lawyer." That sentence alone activates 2 constitutional protections at once, and I'll explain exactly which ones in the next part. Step 5. If it's safe to do so, write down information. The agent's names, badge numbers, time of the visit, vehicle if possible. This information isn't to confront anyone on the spot. It's for your lawyer to use later in case it's necessary to question the legality of anything that happened. Repeat these phrases with me because they need to come out naturally without stumbling in the moment of pressure. I'm not going to open the door. Show me the warrant through the window or under the door. This is not a judicial warrant. I do not authorize entry. I am exercising my right to remain silent, and I want to speak with my lawyer. Practice these phrases with your family. Teach your older children if that applies, because in a moment of pressure, the body freezes, and having the phrase ready is what prevents mistakes. Now, I want to show you the most common mistakes I've seen compromise entire immigration cases. Each of these has a real legal consequence, not just a slip-up. Mistake number 1, opening the door out of fear or pressure. Once the door is opened, this can be interpreted by the agent and later by a judge as consent to entry, even if there's no judicial warrant at all. That's why the closed door is so important. It preserves your legal position. Mistake number 2, signing any document without understanding what it is. Some of the papers ICE presents during an encounter are actually a voluntary departure form. It seems harmless, it even seems like a quick fix, but signing it can completely eliminate your right to defend yourself later in front of an immigration judge. Once signed, it's extremely difficult to reverse. Mistake number 3, answering questions about immigration status, country of origin, or how long you've been in the United States. This might sound like harmless conversation, almost polite, but every answer can become documented evidence against you later in the process. You are not required to provide any of this information without your lawyer present. Mistake number 4, letting third parties answer on your behalf. Children, neighbors, someone who was just visiting. When the family isn't prepared and someone unprepared answers the door or answers questions under pressure, the risk of a mistake increases significantly. That's why this conversation needs to happen inside the home, calmly, before the real situation happens, not during it. I know hearing all of this at once might sound scary, but the goal here isn't to leave you afraid. It's to give you clarity, because fear without information is what leads people to make these mistakes. Information is what gives you control of the situation, even within a tense moment. To close, I want you to understand why everything I've shown you isn't just a strategy. It's a right guaranteed by the United States Constitution. The Fourth Amendment protects anyone on American soil against searches and seizures without a valid judicial warrant. This means the government, including ICE, needs authorization from a judge, based on probable cause, to enter your home without your consent. This isn't a benefit given only to citizens. It's a protection that exists for anyone physically present in the United States. The Fifth Amendment guarantees your right against self-incrimination. That's exactly why the phrase, "I am exercising my right to remain silent," carries real legal weight. You're not required to provide information that could be used against you in a proceeding, whether criminal or immigration-related. And here's the most important point in this entire conversation. These two protections apply to anyone on American soil, regardless of immigration status. Documented, undocumented, visa expired, in the asylum process, it doesn't matter. On these two specific points, the Constitution doesn't ask about your status before protecting you. So here's what I want you to do now. Keep this information in writing. Many immigrant organizations distribute what they call a Know Your Rights card. A small card, the size of a credit card, with these ready-made phrases for you or a family member to show through the door or window if the moment comes. Keep one at home, one in your wallet. Share this information with whoever needs it, with your neighbor, with that coworker you know lives in fear of this every day. And whenever possible, seek out an immigration lawyer before the situation happens, not after. A lawyer can review your specific case, prepare you and your family in advance, and guide you on what to do if something is already underway. Because the truth is this: preparation beforehand is what makes the difference in a moment of pressure. No one thinks with full clarity when their heart is racing and someone is knocking at the door. But if you already know the steps, if your family has already practiced the phrases, that fear loses much of its power over you. You have rights. Know them before you need to use them.